Welcome today in relation to the FLENA Precedent Suite. I'm Amanda Little and I'm going to take you through an introduction to the precedents that are available for use in family law proceedings for FLENA. So basically, for those who don't already know, FLENA has a suite of precedents that relate specifically to compliant CPD and family law rule requirements. So the precedent suite follows the legislated pathway as set out in the CPD and the rules. So I'm going to share a bunch of screens with you today and take you through the precedents. I'm going to show you the integrated and non-integrated versions. So if you're a smokeball user, they will be available for purchase through Marketplace. If you're a non-smokeball user, you would then purchase them directly from FLENA, so the Family Law Education Network of Australia. So basically, when we talk about the way the precedent suite works, we look at the steps as set out by the legislated pathway, in particular CPD. And you would know from the way that it's set out that there's a series of steps that we are required to comply with when we are commencing from the very beginning, so from negotiations onwards. And within that CPD, there is a series of requirements for pre-action procedures that need to be complied with, which are also reflected in the rules. And then subsequently, there's new steps as set out under that CPD and what's required at each stage of those designated dates, from your first return date to your interim hearing date, to your compliance readiness hearing, to your trial management hearing, and thereafter. And each of those dates have a specific set of tasks that are associated with that. So the FLENA suite of precedents has created a precedent for each of those specific tasks. So the first thing I'm going to show you is the master checklist. Now, if you're somebody who's with Smokeball, this is automatically available for double click and generation within Smokeball. If you're a non-Smokeball member, this is how it comes to you for you to see. So essentially, this is the compliant checklist, which shows you the negotiations, the final notice pre-proceedings, stage 1 filing, stage 2 first return, stage 3 interim hearing, and so on and so forth. So as we're aware, this is all set out in the rules in the CPD, and essentially what this will allow you to do is systematically follow the steps so that you are compliant with the overarching purposes and the requirements of the CPD. As we know, there's a real focus on an indication that cost orders could be made against lawyers, which is one of the main concerns lawyers have under the new rules and the CPD. And if you complete stage by stage the precedent suite from FLENA, you will be compliant and you will have met all of your obligations under the CPD and rules. So from a senior practitioner, the benefit of this is that any junior lawyers you mentor can systematically work through and tick and then complete this checklist. You can create workflows around that within Smokeball or whatever matter management system you work in. They can be integrated into other matter management systems from a Word document version. So you would just need to code them when putting them in. But if you're with Smokeball, they are already fully coded and smart, intuitive forms. So essentially, when a client comes to see you, the first thing you would do after they retain you and upon receiving their retainer, if you're someone who does it electronically, such as us via DocuSign, you would then send them the P1 letter, which is the initial letter to client on retention. What that does is it meets each of the individual requirements for lawyers to advise their clients upon retaining them. I'm going to show you what P1 looks like, as it's a good indication of the fact that it's literally a double click, and then and once you've sent that letter out to the client, you know that you've complied with all of your requirements. So I'm going to show you a copy of the P1 letter. So just bear with me a moment while I locate each of them. So this is the P1 letter. So essentially, this is the letter you send once the client retains you. It contains no actual advice related to the matter. What it does is it meets each of your obligations, including section the 190, which is the overarching purpose. So essentially, this is where we provide, if you haven't already provided it, copies of all of the brochures you're required to do, a copy of the section 90 overarching purpose. If your matter is a property matter, a copy of part 6.1 of the rules, your pre-action procedures depending on the matter type, and any further prescribed brochures as required based on the matter type. It's important to know that if you're in Smokeball, it will automatically delete what's not relevant based on the matter type that you have selected. But if you're a non-Smokeball user, you would need to manually remove that. The forms are all intuitive. So even if you're a non-smokable user, it will indicate to you where you need to dictate work. It will indicate to you where you have multiple options of choice and you're to delete a section that relates or may not relate to your matter, and where you need to insert further information. This letter then also sets out the videos that we are required to send the client, which are the ones directly on the Family Court website, gives a explanation of the FCFCOA, the overarching purpose and our obligations as lawyers associated with the overarching purpose, and that the advice that we are required to provide them pursuant to the new CPD. For example, if actions are taken by them to prolong a matter, there could be cost orders that flow. If there's a refusal of a reasonable offer of settlement, it could be considered inconsistent with the overarching purpose. And that if we provide you basically with advice that you choose not to take and then your case no longer has merit, we have an obligation to remove ourselves from the matter. So it actually goes through and it outlines each of those things that we're required to tell our clients pursuant to the new CPD, so that you can, if the matter does proceed before the court and the court is considering making a cost order, that you can indicate, Your Honour, on this date we provided the client with this advice, and that will come automatically from the checklist. So other examples of precedents that people are very interested in that specifically come from FLENA. The main one that I am getting a lot of feedback on, and the people that are already accessing it find it of particular use, is the cost notice. So as you know now, we are required to provide in-depth cost notices. And essentially you need to indicate what you paid to date. Then you need to break down the estimated cost until a compliance readiness hearing of each stage set out pursuant to the CPD. You also need to separate your disbursements from your professional fees. You need to estimate the time of the final hearing, and you also need to estimate your costs of final hearing. So this form, this cost notice, allows you to prepare that document at a single click at each stage required by the CPD. The checklist will automatically tell you that you need to issue that cost notice and how many days in advance that cost notice is required. So as you work your way through the checklist, that's available. So for example, the current cost to date, you would pull this from whatever your matter management system is. So the total cost of the client you would include your professional fees here, the disbursements here, and then the subtotal there. If you're in Smokeball, that will automatically, once you enter in those, it will ask you when you open up the precedent, and then you enter in the data, and then it will automatically tally that for you. This is where you set out your estimated costs until compliance readiness hearing on each of the stages, which is from your first return date to your interim hearing, the gap between the interim hearing and dispute resolution conference, your dispute resolution conference, from your dispute resolution to your compliance readiness hearing, and then your subtotals. This is where you break down your disbursements during each of those stages. So your briefing counsel, subpoena costs, photocopying, all of the ancillary things, you would include all of that within here. Your final hearing, this is where you estimate your final hearing. So, for example, we include standards such as opening and closing submissions as half a day, but it may be the case that your matter is a quarter day submissions, opening, closing, or full day. And then how long you expect each of the applicant and respondent to be in, and then the total amount required. So as you can see, it's indicated here for you to type in the day, but if you're in Smokeball, it will automatically ask you that question. And then break down the costs and disbursements associated with a final hearing. If the matter is a children's matter only, so you would delete this if it's not. Smokeball users would not show this if your matter type is set to property only. You would then also need to put in the source of your funds and how they've been paid and where the future funds will come from, as that's one of the requirements under the CPD and the rules. So what that allows you to do is, if you're a non-Smokeball user, you would generate this document once at the beginning, you would put your estimates in, and then at each stage you would literally create an additional copy of that document, delete the stage that you have passed, update the fees that you have paid, and just re-add your subtotals and adjust accordingly. So it does cut significant amount of time out of preparing that cost notice on each occasion, which has become a quite laborious task for most lawyers. So other things people have been interested in and have asked me to share includes things such as the written notice of intention to commence proceedings. So the CPD is pretty clear on what's required for that, as are the rules. So the notice of intention to commence proceedings states the rule in which it's made, and then this is where we are either providing our notice of intention or to the other side if, for example, it's a solicitor matter, or alternatively, if they're self-represented, it's got the two options. And then pursuant to Rule 3, we confirm in our correspondence, and you would insert the date of your last correspondence, that we provided them with a relevant pre-action procedures prescribed brochure. That's one of the first letters that gets sent out underneath the checklist. So each of those are set out individually. And then it goes through each of the things that you're required to identify, which includes the issues left in dispute for both children and property, the orders as sought if you were to commence proceedings, the genuine offer to resolve the dispute, which must be actually different to the orders as sought, the basis of the offer. So you are required to actually outline the basis of the offer. If it's a 79, you have 75 2 factors, or the section 60C factors in which you say the offer is a genuine offer of compromise. And then leave it open for a period of 14 days, which you are required by the rules to do. And then the rules also state that, in relation to not accepting the offer, here are their options. So that's essentially what the rules require. So what would happen is you would then generate that letter, you would send it to the other side, you would diarise in 14 days for a series of responses. So the checklist, going back to that, to show you how that works, you would pin this to the commencement of your matter. So when you first opened your matter, you would pin this checklist, and then you would literally systematically work through each. So the first thing we do is send the letter to the client, which means that all of our obligations are completed. We then send the initial formal letter to the client regarding children and/or property. This is a really detailed letter of advice. So what it will do is it will set out all of the advice and the basis of the advice that you give. So if it's a children's matter, it will explain the overarching principles. It will explain the umbrella principle of the best interest. It explains section 60CC considerations, and it includes sections for you to dictate client-specific advice into it. So what it means is that all of the laborious task of setting out and explaining how the legislation works is done, and all you would need to do is give the client-centric advice within that correspondence. So I'll show you a copy of that one, as I feel like it's a really good one to have a look at and to see how that precedent works. I'm just going to stop this share, and I'm going to share again. So this is your P2 letter. So this is the letter to the client where you actually set out advice. So if you're in Smokeball, it will automatically remove anything relating to property if it's a children's only matter, and vice versa. And if it's a property and children's matter, it will show all the relevant sections of the letter. So basically it will set out the way of reaching an amicable resolution. It explains what mediation is. It goes through all the requirements we're required to tell the client in relation to mediation and section 60I certificates. It talks about confidentiality. It breaks down that advice. And it then sets out to the client, if you reach an agreement, here are your options. If it's property, or if it's children, or if it's both, here are your options. It then sets out the property aspects, so consent orders, binding financial agreements. We explain what makes a property settlement just and equitable. We talk about section 79 contributions, and you'll notice here that we have little highlighted sections that say dictate advice as to appropriateness in the client's circumstances from the section 79 contributions. So what that means is, as a lawyer, you would double click the letter, you would save it into your system, and then you would open it and you would dictate to your secretary, or type if that's your preference, the specific requirements for each client in each highlighted section. So you are prompted by the precedents to dictate the client-centric advice in. Section 75(2) adjustments, it lays them out, explains what they are, and then you would dictate advice into that section. So what it would mean is it takes out so much of the legwork required, and all of the precedent required meets all of the requirements of the CPD, as well as explains the legislation and the provisions around the advice. So all you're doing is providing the specific client advice, as opposed to going through each of those sections, because it's already detailed. We set out, for example, finality of orders, and explain that once orders are made, they're final and they're in place. What if we're unable to reach an agreement, and then sets out the purposes of, going to court. Children, this is the children's section. So we talk about parenting plans and consent orders and what are the differences are. And then you would dictate the advice as to which one you tell the client that is appropriate in their circumstances. If you're unable to reach an agreement as a children's matter, this is what needs to happen. It sets out the section 60CA children's best interest, talks about the section 60cc considerations, each of them and what they mean. And then you would dictate the advice specifically to your client about what you believe the court would make order-wise. We break down parental responsibility. We explain what that is. And then you would provide your advice here in relation to whether or not sole parental responsibility or equal shared parental responsibility was appropriate in the case. We break down the time the children will spend with each of you, the difference, what shared care is, how that will work, the advice, and then also we identify if there's any risks. Either we confirm that there's no risk factors, or if it's the case where there is, you would delete that and you would identify which of the risk factors exist and your advice. We also have a section here for special arrangements, sort and niche legal issues. So if you're running a Cannon's argument, you have a relocation issue, you have some sort of niche area that needs to be determined, you would then provide your special advice in relation to that specific section. We once again go through the obligations which you're required to tell the client, and then we give them where to from here. And this is where we say, okay, so if your matter is a property matter, the next step is to exchange financial disclosure, prepare a balance sheet, provide you with written advice, and then put an offer to the other side. So this is all laid out step by step in these precedents. So basically what we do is we've set up in this precedent system a systematic process through all of the requirements of the rules in the CPD to make sure you're compliant. And then in addition to that, the advice is contained within the letter, and then you additionally add your client-centric advice. So going back to that checklist, instead of continuing to show you each individual precedent, I think you get the idea of the complexity of what's actually in there and how much work it will save you by using it. We just need to have a look at the negotiations and what's set out in that. So the letter to the client and the obligations, primary letter to your client, primary letter to the other side. The property division letter of advice is a really good precedent. It basically sets out and allows you to systematically break down the balance sheet for the client, explain the super pool, the non-super pool, the total pool, the 79 adjustments, the 75-2 adjustments, the just and equitable expectation, and then you can give the client advice in relation to here are your options for settlement, or if you've already received an offer in from the other party, here's what that offer means, and here's you should accept it, not accept it, or counter offer. So all of that is built within the precedent. When you get to the pre-proceedings, you'll see here that you've got all the standard letters. So the notice, which I've already showed you, what happens if there's no response, that letter comes out, or if there is a response but no resolution, prompts you to issue your tax invoice. Your stage 1 filing, there's a precedent regarding letter of submissions for the division. So if you're seeking a division 1 as opposed to a division 2 listing, urgency and specialty lists. It also sets out what you're required to file so that your secretaries, yourself, or your juniors can tick that and say, yes, we have complied with that. And then they date the date that that was all complied with. Your first return date, you're notified that you're supposed to do your cost letter to the client a minimum 1 week prior, your letter to the other side, and the court with the cost notice, your final hearing estimate and confirmation of genuine steps minimum 1 day prior. So what you would do is once you complete each of these tasks, you would look in advance and then you would diarise those tasks that are coming up so that you get that diary entry to say, don't forget to do your cost letter 1 week prior to the next court date. So it becomes a systematic ticking process, and then you make sure that you are fully compliant and you're not left open to a cost order. So you've got the signed statement as to costs, your disclosure undertaking, a summary document. So this is particularly useful, this summary document, as the CPD outlines a series of things that you're supposed to be prepared to answer on your first return date. This summary document will ask you a series of questions if you're in Smokeball, or alternatively will open up for you to populate yourself prior to your first return date. And what it means is that no matter who attends, whether or not it's yourself, a junior in your office, or you're sending another solicitor at your office, you would be able to say to them, look, the prepared summary document is sitting on the file. Let me show you what that actually looks like, because it's quite useful. It also helps you prepare for each of the matters and before you attend court. I'm just going to show you that. So the summary position document follows the CPD. In that, there's a series of things under 5.10 that we are required to know. So the first thing is the orders that can be made by consent. You need to indicate to the court that yes, there are orders, or no, they're not. And if there are orders, you need to know what they are. So you would dictate the agreed terms. You can also provide a copy of this document to the court in advance. It is prepared and ready to be filed if you wish to do so under other correspondence, so the court has it on record. Compliance with pre-action procedures, each of the responses. So you can say, yes, our client has complied, or we were unable to comply because the other party didn't respond, or because it's not appropriate due to family violence. The directions as sought, the issues in dispute. So you are required to identify each issue in dispute, what proposed steps are to resolve that issue, and whether or not it's a final or interim issue that needs to be determined. So an example would be, there's no agreement as to the value of a property. So the issue in dispute would be the value of the matrimonial asset. Proposed steps, obtain a registered valuer to value it. Is this a final or interim? It's both. But essentially what we would do is we would seek an interim order for valuation, which would then be reflected in the orders as sought by you. And then you would say to the court that that's something that can be made and the issues under dispute that can be determined by this. You then need to indicate whether or not an interim hearing is required, how long it will be, if you do require one, and whether or not you require reasons. That's one of the requirements under the CPD. Also, dispute resolution. Is it appropriate for private FDR? So once you start using these precedents, you'll get to know them very quickly. So you'll know, yes, it is suitable for private FDR. So you would delete the section in relation to court-based, because you know it's a private FDR matter as opposed to a court-based FDR matter. Is it required in individual case management? Are you suggesting it should come under the CPD guidelines? And if it is, why? So for example, if you're like, this is a matter where there's some significant risks, there needs to be time built into this matter and it can't be heard within the 12-month timeframe as set out by the CPD, then you would say it requires individual case management outside of the CPD requirement. Is there urgency? What further orders are required? So what it does is it prepares your basic outline of the position of your client, and you can serve that on the other party and on the court. The CPD actually indicates that you should have indicated that to the court in advance, but it also allows you to prepare your colleagues. So it's basically a pre-done memo almost as to the position of the matter and if it's ready to proceed and what needs to happen on the next court date. So going back to the checklist, we then move to interim hearing. So all of the requirements of an interim hearing are met here, which includes your 7 days prior, file and serve materials, letter to client regarding their obligation, their obligations and cost notice, which is the standard letter we're required to send saying, you know, you mustn't refuse reasonable offers of settlement, cost orders could flow, etc., which is basically the section 190 overarching purpose. We need to do a letter to the client confirming no substantial change of its property. So one of the requirements is that we confirm with the client prior to each designated court date that there's been no substantial change, and if there has been, we would need to do either an updated financial statement or a short affidavit of no longer than 300 words that details that change. For example, if there was a disposal of a significant asset, we would need to file an affidavit confirming that was the case. Now, each of these precedents lay that out, and it's quite systematic in the process. We move to the dispute resolution and post-dispute resolution process. So for example, here you've got, your cost notice letters, your letter to the mediator, your post-FDR letter to the client, which identifies if an agreement was reached or a partial agreement was reached, what issues are left in dispute, what needs to be determined, and how we're going to proceed further. That's all set out systematically within that precedent also. Your compliance readiness hearing, so each of the precedents as laid out there. So for example, if you a letter to the other side saying we propose the Annexure A trial plan as set out, do you have any objections? If you do, what are they? Do you require any amendments? Or we say we need these trial plans, or we identify this as a fast track hearing and here are the submissions as to why, and here's our understanding of the issues left in dispute and further minutes required to resolve those issues. So each of these precedents outlines each step required. So the benefit of using this system is this checklist is a master checklist that sits on the front of your file. So whether or not you're paperless or you're a paper file, you would have that and it would be marked off systematically each time one of these tasks is completed, and the associated precedent will be in your system. So if you're in court and someone says, the judge says to you or the registrar says to you, when did you send the proposed trial plan to the other party? You would literally be able to go to your checklist and say, Your Honour, that was sent on the 15th of September 2022. Automatically, you would need to look for the correspondence. It's within that checklist. And because it's systematic and it's timed out, you will, as long as you comply with those timings, you will meet the requirements. We move down into your trial prep, which includes, the list of authority which counsel intends to cite, your letter to the expert notifying from the need of cross-examination, letter to client to set their expectations for final hearing, explaining what to expect, how it works, all of those kind of things. Your trial management, cost notices, schedule costs if you have to prepare one, if it's likely you'll get a cost order, your trial, post-trial and judgment, so the outcome of the court hearing, all of those things are set out. So basically from the very start to the matter to the very end of the matter, there is a complete precedent suite from FLENA, which covers each of the stages of the FCFCOA, including all of the CPD requirements and the rule requirements. FLENA is also going to release within the next 6 months specialty precedents in addition to this, for example, for Magellan, Lighthouse, Everlist, complex matters. All of those will have their own bunch of specialty precedents, which will feed back into this master suite of precedents. So from the very start to the very end, systematic process, ticking all the boxes and not leaving the parties open to cost applications for non-compliance with the CPD. So hopefully that provides you with a bit of information as to the precedents that are being offered by FLENA, and feel free to give us a call, jump online, www.familylaw.edu.com.au to have a look at what we offer.